My name is Karen Haase. Can you hear me if I don't stand at the podium? Okay, and if any, I'll try to take visual feedback from you if any of you are struggling to hear, let me know. I am an attorney. I live and work here in Lincoln. All I do is represent public school districts in the state of Nebraska. That's my entire practice. There are actually 4 of us in my firm that are in the school law section. Before I went to law school, I was a teacher, so I joke to my clients that I'm a recovering teacher. And when I got this job at the firm, my mom said to me, "Will there really be enough work doing just schools for you to do, like have a job full time?" Like, "Oh yeah, Mom, yeah." So in addition to the stuff that we're going to talk about, I do teacher terminations, union negotiations, lots and lots of student discipline, which all too often involves kids that you guys are representing, and just general advice. I don't represent every school district in the state of Nebraska. I don't represent Lincoln Public Schools or Omaha Public Schools, but really there's a pretty tight band of us that do school work. So if you're having issues with the school district, questions, problems, call me. And if I can't guarantee that I'll fix it, but I can guarantee that either I can talk to my client or I can put you in touch with the attorney that represents that school. And I know them all. For those of you that are techie, this QR code in the bottom corner of the slide will take you to a digital version of these materials. It's just a matter of whatever your preference is. So there's that. Last thing, and then I'll quit clearing my throat. I used to go to school conferences. I do a lot of continuing ed for schools, and we would all say stuff about HHS, those caseworkers. Well, the juvenile court judge said, and so when I started dipping my toe into your world, I heard caseworkers saying, "Well, and then the school," and judges say, "Well, that principal." And you know what I've decided? We all have really hard jobs. We all have been given a mandate by the unicameral with insufficient resources to do what they've tasked us with doing. We also deal with difficult populations, and it's time for us to stop taking pot shots at each other, right? I've made a commitment to stop saying that to my clients. I think you'll get along better with my clients if you stop saying, throwing shade about them on the side. I think we should all get on the same page. And so I'll confess to you that I have been the person saying, when you're talking to the principal, telling the principal, "You tell that caseworker, she doesn't know what she's talking about." And sometimes you don't. But I think we'll do better if we try to come at this from a collaborative approach, okay? When I clerked for Judge Beam, and not that he knew me very well, but one of the last things he said to me was, "Karen, as you go into private practice, you need to know the 5 most dangerous words in the practice of law are, 'You can't do that, Judge.'" But judges, one of my goals here is to tell you a couple of things. You can't do that, right? I've had judges order, in a domestic case, divorce case, a child will go to Schuyler Public Schools and receive an IEP. You can't do that, judge, right? Or juvenile, a criminal case, child is placed on probation and sentenced to attending school regularly. We aren't jailers, right? If the kid comes to school with a bag of meth, we're going to expel him whether or not you ordered him to be in school or not. So hopefully maybe we can clear up some of those sort of miscommunications between the 2 areas of law. So here's the plan for it. I'm entertained by this because I'm of a generation that watched a lot of, yeah. My kids don't think this is that funny because they didn't watch Wile E. Coyote. Here are the areas I thought we'd talk about this morning. We will take at least 1 break, maybe 2. If you need to take a break, start squirming so that I know it's time to stop. And if you need to get coffee or go to the bathroom or whatever, it's going to be really laid back. It's also much more interesting if you ask questions rather than me just stand up here and drone on. So here's what I thought we'd do. Residency, which you guys don't think matters, but this is the most common interaction I get, phone calls I get from my clients involving students in the juvenile justice system and other court-involved students, is where does the kid go to school? So I want to walk through that with you all. Attendance, there have been many changes in the attendance laws. Like every year, the unicameral has changed. This year, we've changed again, and we've gone back to the system we had like in 1994. So I want to touch that. Disabled students, a lot of the kids that you are dealing with are students with disabilities, whether that be under Section 504 of the Rehabilitation Act or under IDEA. I think a little primer on those laws would be helpful to you. If you think that would not be helpful, let me know at a break and I'll skip that, but I think you want that. And then finally, student discipline. That's the second most common time I get a call from a kid that's from a school that's working with a kid that's court involved. The kid's a badass at home, he's a badass at school, right? And so he's gotten in trouble, and now we have conflict with the caseworker or the juvenile court about what we're going to do with that kid to discipline him or her. So I wanted to walk you through the Student Discipline Act, and then we'll finish up with the special discipline rules that apply to disabled kids. Okay? Does that sound like what you signed up for? Awesome. Okay. So the first thing I want to talk about is residency. Oh, come on. That's those of you that aren't laughing don't have kids at home for the summer, do you? Because this one today, you know, on my third trip to the grocery store of the week, I'm loving this cartoon. So here's the thing. In Nebraska, where the kid goes to school is all driven by 79-215. That's the statute that I have flagged in my statute book. I have a little flow chart on my computer. That's where we go when someone calls and says, do we have to let this kid into school? Okay? These are kind of the areas that we see over and over again, questions coming up. Is the kid a resident? Is the student homeless? Contracted students, we'll talk about option students, state wards, and students who aren't wards but who've nevertheless been residentially placed somewhere other than at home with mom and dad. This is funny as parents sending kids to school in the summer, but I also kind of think sometimes this is how caseworkers, foster parents, house parents, we're piecing together a plan to figure out what we're going to do with this kiddo for whatever reason he or she can't stay home. And I think you guys sitting around making the case plan go, thank God, from 8:15 to 3:15 he's not our problem, right? We'll kick the child onto the school bus and whew, that we don't have to cover that time. And so, I get it, but I think we also sometimes put a monkey wrench in your plans that way. So first off, residence. This is 79-215 sub 1 and sub 2. Sub 1 says a student is a resident of the school district in which they reside. Anybody else see the inherent circularity in that, right? Basically, unless some other subsequent provision overrides it, a kid resides where he or she keeps their jammies, eats their supper, you know, has breakfast in the morning. A couple of just illustrations to help you see how literally the Department of Education takes that. We had a client out in western Nebraska with an individual who had lost her ability to take in foster children. I don't know if she was I don't know. The 43s is your world, right? 79s is my world. So she couldn't take foster kids anymore, but she still wanted to continue sort of her lifestyle. I mean, I think she got paid. I think that's how she paid her bills. I mean, I don't mean that to sound unkind. It's just true. So what she did is she went on the internet and started advertising for like private foster care placements, basically, right? Is your child have fetal alcohol syndrome, reactive attachment disorder, any other really bad mental health issue that you can't handle? I'll keep him. And she was like running a boys ranch. So she was getting kids from Colorado and Kansas and South Dakota. Right. Strangers would just send their kids to this woman and say, here, they're like severely impaired kids, to this woman and say, here you go. Well, her business model was, okay, I'll send the kids to small rural school district from 8 to 4, and then all I have to do is keep track of them the rest of the time, right? So a school district with very few like full-time special education staff suddenly has this influx of, I mean, reactive attachment disorder is one of the most difficult impairments for a school district to deal with. I don't know what you guys' experience is with it, but it's really hard. Fetal alcohol syndrome, another really difficult educational challenge. Autism we could handle, but these were all sort of the mental health impairments that schools struggle with. And so the school called me and said, what do we do about these kids? And I said, I don't think they're residents. I don't think they reside in the school district. They're sort of at summer camp, right? This is respite care for mom and dad. So that was our position. We said, we're not going to enroll these kids. Now, little footnote. I think that sometimes you all feel like we refuse to enroll because we want this kid to be your problem and not our problem. Sometimes we need to not enroll because By enrolling, we're empowering an unhealthy pattern of behavior by adults. And I think this is a great example of that, right? It's not that I thought these kids should be shipped to Albania and, you know, fed C rations and never educated by anyone. But by us just accepting this woman's plan and enrolling these kids, we were empowering what I viewed as unhealthy decisions by this woman and by these kids as parents. Just, do you at least see where the school was coming from there? Plus, we don't have the resource. I mean, we could not adequately serve them. So I called the department and said, Brian Halstead, who's general counsel at NDE, great guy. If you ever need help from the department, he's the person to call. Brian, we're not going to enroll these kids because they're not residents. And you know what the department's position is? They were residents because they slept there. I said, but Brian, they're going home for Christmas. They're going, you know, but nope, he took the position that if they packed a suitcase, they're residents. I said, so when my kid goes to football camp in Scotts Bluff, he's a resident. And Brian said, if he wants to go to school, he is. So just so you know, that's how literally NDE takes 79-215 sub 1. Now, that doesn't solve your foster care problem because there's subsequent provisions that override this one. But the kid that's living with grandma because he can't get along with mom and dad and there's no official fostering going on, right? The girl that wants to move in with boyfriend. Mom and dad are leaving town, senior in high school wants to stay and live with a friend. 79-215 sub 1 really does, I don't want to say solve a lot of problems, but it's a place for you. I want you to know about it because it's a way to get kids enrolled legitimately in a school district where they want to attend, because the whole residency thing is pretty loosey-goosey under how the department is interpreting 79-215 sub 1. Okay? Oh yeah, I'm sorry, yeah. And they're recording this, so I'm going to try to remember to always repeat your question. Otherwise, I have to run over ridiculous with the microphone. So she said, by department, you mean Department of Education. Yes, in my world, the department is the Department of Education. I know in your world, that's DHHS. I'm sorry. And I'll try to fix myself on that going forward. So yeah, Department of Ed, who is the boss of my people, just like HHS is the boss of a lot of you people. That's who we listen to on these issues. Great question. I like it when isn't it more interesting when people ask questions? Okay, good. Can I reinforce that good behavior in you? All right, that's 79-215 sub 1. 79-215 sub 2 is another area where I've seen like an easy answer to questions that sometimes folks in the juvenile justice system don't know this. Legally, a child is a resident of any district in which either one of their biological parents reside, okay? Or adoptive, actually. I mean, I should take out biological. Either one of their parents reside, okay? So let's say my husband and I decide to call it quits. And so I moved to Crete, which is where I graduated high school from. He moves to Dorchester, which is where his family is from. And Eli, my freshman in high school, decides to move across the street to live with the neighbors. Okay? Eli can, without any court involvement, any special process, any paperwork being filed, Eli can attend school at Lincoln Southwest, that's our residence, at Crete High, where I am, and at Dorchester High, where David is. Okay? Because he's a resident of 3 different places. You guys all knew that. Oh, no, because I've had people struggling, and then I ask, well, where does mom live? Well, she lives in Lincoln. Problem solved, right? So it doesn't matter where the kid is, either bio parent or adoptive parent, their residence also will allow the child to attend school in that district. It does create problems, judges. If you could help us, mom has, I'm down with the whole creative parenting plan thing, but when you have mom have the kid for a week and dad have the kid for a week, I have had kids who have been enrolled in one school for a week, disenrolled, enrolled in another school for a week, disenrolled. Oh my God, yeah. We had one where it was this real creative parenting plan where it was like real young kids, and so they had them in, there's some kind of research that says longer stretches of time is better than these short stretches. So somebody was ordering like 4 and 6 week periods of alternating parenting time. And so the kid would just get going into kindergarten in one place, and literally, I mean, she changed 3 times before I finally said stop. And then we ended up filing, intervening in the domestic case and asking the court to rule where the kid should go to school. Because we really are, as a school, our rights don't trump the rights of a biological parent, right? We can't really say sorry, Dad, that's a bad idea. You can't disenroll your kid. And so judges, we could use your help here. If you would, and I have parents all the time think, I have custody of the kid, so I have control of where she goes to school. Well, no, what does the order say? Did the order vest educational rights jointly? Because then we'll have to defer to the biological parent because their rights are superior to ours. Okay, so that's 79-15 sub 2. Questions on that? Yes?
You had said that one of the things judges can't do is order a kid to go to school to a particular place. So in this, are you saying you intervened so the parents would stop doing this, so you're ordering the parents to make a decision?
Exactly.
But
yes.
Lincoln Public could still be like, now we're not taking them, and the court has no authority over Lincoln Public to keep the kid.
Okay, and I'm gonna, your question is, okay, I said earlier the judge doesn't really have power to order the school to do stuff, but now I'm saying that the judge has power to order where the kids go to school. Sort that out. You're exactly right. The court has jurisdiction over the parties in front of it. So mom and dad are divorcing. The court can, you can order dad. You will not, you will enroll this kid in Aurora Public Schools and leave him in Aurora Public Schools because you've got jurisdiction over dad. And if dad disobeys that and tries to put the kid in Central City, we'll still have to enroll him, but then there's a contempt action against dad, right? And so again, you can't do that, judge. It makes me nervous. But really, judges, if my client's not in front of you, you can't order the school to do anything. You're not the boss of us. Yet, but you do, but you can order the parents to do stuff, right? And so that's what I'm saying, yes. And again, the creative plans I like, but parents come out of the courtroom not really understanding who has the power to do what. And so yeah, make the order bind the parent, not the school. Great question. There was another question, yeah.
You mentioned educational rights, and maybe this is something you're going to touch on later, but when a child's put in the legal custody of the Department of Health and Human Services, and parents say, well, I still have educational rights, what's that mean? What do they have power to do?
Yeah, the question is, okay, I mentioned educational rights. When a kid's put into whatever, the system, let's say put into foster care, because I can't follow all the other little tweaks and valleys, who has educational rights? Under Department of Education rule, a caseworker cannot have educational rights. Technically, HHS is the guardian, but there's no statute, because I've searched high and low to look for something that says DHHS is vested with educational rights. And unless there's been an order by the court saying mom's educational rights or dad's educational rights are terminated, those educational rights continue. So if we go to an IEP meeting, for example, bio mom has lost custody of her kids because she's drug involved, she still is the parent for purposes of signing off on that IEP as far as the school's concerned. Now, I'm going to tell you later, we don't have to do, just because she's the parent and she has signing power, that doesn't mean she has veto power. And that's a confusion that schools and court workers have together. So if everybody agrees that it's a really bad idea to do what drug-involved mom wants to do with kid, we can go ahead and do, but mom has to say she doesn't agree. So but she still has those educational rights. Now,
pick what school the child's going to go to?
Technically, she can pick what school the child's going to go to. But if the kid's in foster care, the Fostering Connections Act would say that the kid would stay in the same school building, and so hopefully that settles it. But if there's a best interest determination, the school district is going to respect that best interest determination. And I think that's a DHHS problem to figure out how you respect mom's educational rights when you're making that best interest determination. But the good news is my clients, once you give us a written best interest determination, we'll hide behind that. Okay, and we'll let mom sue you. Now, there was just a decision by the Nebraska Court of Appeals, was that last Friday, judges that followed this stuff, saying that the loss of educational rights was not a sufficiently large loss to allow an interlocutory appeal. Did you? Am I misremembering that? I just read it. If somebody emails me, I've got that decision saved in my Evernote. But anyway, the appellate courts just addressed this question of educational rights. And they said, yes, the rights remain with the parent, but the loss of those rights was less significant than other kinds of parental rights being lost. And I'm sorry, I should have pulled that decision up this morning before I just can't remember exactly what the fact pattern was. I'm sorry, but if anybody wants it, email me, I've got it saved somewhere. But yeah, that educational rights question is a gray area, very gray. Okay, okay, How about homeless? Do you feel good about McKinney-Vento, or do you want me to touch this? Touch it? No? Give me something here, people. Yeah.
Can I clarify something? With that piece, you do not need to have school records when you're home. Is that part of McKinney-Vento?
Yeah, homeless. Yeah. If you are homeless, if you meet the definition of homeless, then you are entitled to continue attending school in the school building where you were attending immediately prior to you becoming homeless. And the school district, what we would call in the school world, the school district of residence, which is stupid because they're homeless, right? But I mean, the school where the kid is attending, that school, has to pay for transportation. That's the piece you all want to know and need to know, okay? My clients are very weak on McKinney-Vento, so if you have a school pushing back, you might suggest call your attorney. So the kid that's placed in awaiting foster care and he's sitting in Beatrice somewhere in some kind of temporary placement, Lincoln Public Schools, if that's where the student went to school before they were put into this, wherever they are, Lincoln Public Schools has to allow the kid to continue attending school and provide transportation. That's the piece I think that makes a lot of difference.
And then another question, because we've got that 20-day rule of absences, and we've had some people, some families who in Omaha become homeless, go to maybe the Council Bluffs shelter, and they immediately start school there. But the Omaha Public School has no idea, and they're like,
right.
They haven't gone because, and they said their school records haven't been transferred, so they haven't gone. But someone said something.
Yep, that's right. If the person making educational decisions for the child decides to enroll the kid wherever they are, so in Council Bluffs in your scenario, question was, sorry, I got it from kids from Omaha in a shelter in Council Bluffs, starts going to school in Council Bluffs. Omaha's not transferring the records, so still calling the kid truant, which I'm not supposed to say anymore. So how does that work? Yeah, the school district where the shelter is supposed to immediately enroll the student without requiring records to be transferred, and that enrollment becomes effective upon actual attendance of the child. Yeah, and that's in the omnibus provisions of the No Child Left Behind. It's called the McKinney-Vento. I think I've got the statutory side here. So let's start by talking about who's homeless, because this is a list that's a little bit different, I think, than when I think homeless, I think of the scenario you just described. Living in the mission, living in a shelter, living in the car, right? Which includes those kids. It also includes students living with family because of economic conditions. We had a family that sold their house. They were building a beautiful home on the golf course out west, but they sold their old house before the new house was built. They started living in a hotel in a school district separate, and sophisticated dad who made a lot of money but was nonetheless making sure he got every nickel out of the local school district, called and said, my kids are homeless, you got to provide transportation. My school was outraged. Sure enough, they were, right? Because they were living in a temporary place due to economic circumstances, okay? Mom can't pay the rent, and so she moves in with grandma. That kid is technically homeless. So that's, again, I think that's information that will make my clients crazy, but will be helpful to you. Kids that are abandoned, kids that are awaiting foster care, that's another area that my clients don't often know about, but I want you to know about because that's our obligation under the statute. Living in cars, migratory children, which is a huge issue in some areas of the state. I don't think so much here in southeast Nebraska. Abused, homeless, not yet in the system, and kids that have aged out of foster care and yet still don't have a place to live. We've solved that problem by statute, right? Because we've solved all the aging out problems. Sorry. Yeah.
Abandoned. Explain that in a little more detail.
The kid that gets kicked out of his house because dad can't handle him anymore, that kid meets the McKinney-Vento definition of abandoned. Our bigger problem is getting that kid a place to sleep, but if he's sleeping in a place that's not within the boundaries of the school district where that kid was attending, he is entitled to continue attending and he gets transportation. Good?
Are there limits
Nope.
to that transportation? Like if the kid goes to stay with an uncle or aunt in Seward overnight, somebody in Lincoln would have to transport him?
We went through this, don't tell my mom I'm taking off my jacket and I'm sleeveless. So that's kind of unprofessional, but I'm getting excited. So yeah, no, we actually went, when No Child was passed and McKinney-Vento was attached to No Child, we actually wrote the Department of Ed in DC saying, okay, Mom is in Scotts Bluff. Kid can't live with mom anymore because she gets evicted. Kid moves to Lincoln to live with grandma. We said to DC, you don't understand how big Nebraska is. Are you really saying Scottsbluff would have to send a van for that kid every day in Lincoln? And they wrote back and said yes. Well, come on, okay, that's just stupid. So there's no, and there's also no time limit. There's no geographic limit and there's no time limit. I've got a case coming up where the school said, okay, long enough, this should count, you're not homeless anymore, you're just living with grandma. And the court said no. Okay, so here are their rights. They are entitled to remain in their school district of origin. They're entitled to transportation, entitled to immediate enrollment. That's the Council Bluffs question, even without records. Now, schools in Nebraska are going to say, where's your birth certificate? Where's your evidence that you had a vision exam? Where's your immunization records? And usually that's the school secretary, truly. In places, even in Lincoln, that's the school secretary that's doing that, okay? Who are good people, but not super sophisticated. So don't be surprised if you're trying to enroll a kid as a homeless kid if you initially meet lower level bureaucratic resistance, because the secretary has the list of stuff she's supposed to get, right? And so that's going to be your pushback. The other thing is, just so you know, even if a kid is homeless and we enroll him or her without a birth certificate, what's it called? The Missing and Abused Children Act. There's a statute in the 43s that says if we have a kid that enrolls without a birth certificate, after I think it's 6 weeks, we have to tell the sheriff. So because the idea was to catch kids that a estranged spouse had grabbed and run off with. So if you do enroll one of these students without a birth certificate, eventually we're going to have to call the cops, which is, it's not the end of the world, but that's just what we have to do. And then every school district is supposed to have a homeless student liaison. So every school, let me put it to you this way. Every school district has a policy that has identified a homeless liaison. The Department of Education has made sure they all have policies. Many times the school has no idea that the policy exists, and the liaison may not even know that they're the liaison. You laugh, it's just true. So if you're struggling with a kid that you think is homeless and you need help from the school, a great place to start would be to jump online, find the school's policies, locate the liaison, call that person, inform them that they are the liaison, and then that might get you some traction to start working. Yeah. The liaison is, what does the liaison do? The liaison is supposed to facilitate navigating whatever the requirements are to get that kid into school. They're also supposed to really, truth of the matter is, the liaison is the one that hits the superintendent on the head and says, the law says we have to do this. And sometimes the liaison is the one that calls the Department of Education and thinks us out, which is okay. And then they're supposed to, there's an appeal process in McKinney-Vento. We've never really had to use that because once you get to, I think part of it's because the education bar is really good. So once somebody calls one of us, we pretty much get things squared away, whether it's me or the Perry firm or whatever lawyer it is. But that liaison also initiates that due process provision of McKinney-Vento.
I have another question.
Yeah.
About like because for a lot of our families, I work with state wards, the parents do wind up living with their mother or a relative for sometimes 6 months to a year because they can't get a job or what have you. Does it matter if the parents are receiving economic assistance, food stamps or what have you, and their food stamp paperwork goes to that address, they actually get mail at grandma's address? Does that affect anything?
The question is, so mom's got issues, so she ends up moving in with family, then she gets state aid there, SSI, whatever it is, she's getting food stamps. When does living with grandma turn into mom's address is really what you're asking.
Yes.
I don't have a case that answers that question. This is actually, stink. I'm sorry you can't see the title. Well, you've got it in the materials. This IDELR, just so you know, special education is such a weird area. We have our own reporter. So if you ever see IDELR or LRP citations, lawyers, that's what that means. It's in the special ed reporter. So this is a case from 2001. Student moved in with relatives after a house fire, okay? Actually, student lives with grandma. Grandma's house burned down. Grandma and student move in with aunt, I believe, and then they're living with aunt. The school initially the school initially let the kid continue out the school year at the district of origin because the house burned down, right? Next school year, the school district said, it's over, right? Now you're just living with your aunt. You're not homeless anymore. And to schools, everything goes on a school year calendar. So that I can see the logic of the school district of origin. So they refused to enroll the kid because he wasn't a resident. They said the kid's not homeless. He sleeps in a house every night. Eventually, sometime the residency transitions. The court said, no, this kid meets the definition of homeless in McKinney-Vento. So I know 8 months is not enough to transfer residency, because that's how it worked out in this case. I can't find a case that says, student, thou art no longer homeless, using the circumstances you and I are talking about. So I think it's indefinite. Now, there comes a point at which we may find better and different ways to provide those transportation services, but ultimately that cost, as I read McKinney-Vento and as I read the US DOE decisions, that cost is borne by the school district of origin. Other questions? The other crappy fact in this case is the school district where the aunt lived also wouldn't enroll the kid because they said he wasn't, you know what I mean? It was one of these kind of deals, and that's a bad fact. But that fact wasn't in the decision. So even though I think that drove this decision, it's, yeah.
Okay.
I'll come to you then, whoever. No.
He fits under McKinney-Vento.
Yes.
However, had he chosen to go to the school district at Ants, that subset 2 would apply because he's a resident there.
Yes,
correct?
yes. So the question is, this kid is homeless, so he can continue attending the school district of origin, yes. Also the kid, if the kid wanted to, could attend the school district where Aunt's house is under subsection 1 of 79-215, because that's where the kid is sleeping, right? And yes. Okay. And now the reason I'm hemming and hawing, as a matter of public policy, if the kid has moved to the school district, I think it is better for him or her to attend the school where he or she is living, but I don't get to make that call. The person with educational rights gets to make that call. Okay, over here someone had a question. No? Did I dream it? Oh, yeah. Yeah.
What about, have you seen any research on states that actually changed McKinney-Vento or added foster kids to include them in that whole scenario?
I know that has happened, but I haven't seen any. I've not seen any written decisions involving those kids, and I haven't seen any research about what's best and whatever. Really, making a foster kid homeless would answer the transportation question. That's really, it would be a way for the state to announce who they think should pay for transportation, and we haven't done that in Nebraska. Other questions? Okay, so that's homeless. Next is the kiddo that moves during the school year. So now I have another way. See, do you see how 79-215 is like the God's gift to school lawyers, right? So I have another way for you to get this kid that's in Council Bluffs. But let's not make it Council Bluffs. Let's make it Papillion. Okay, so it'll be easier. So let's say the kid moves during the school year. Technically isn't homeless because mom and dad just moved into a different house, a cheaper house, a different apartment, whatever. And he wants to finish out the school year at Papillion La Vista. Can he do that? Yes, he can. A school board may allow a student whose residency in the district ceases during a school year to continue attending the school district for the remainder of the school year. Most boards have made this decision via policy, and the 99.9% of school districts' policies say if a kid moves during the year, he or she may finish out the year in the school district where they started, okay? But if you've got any, you can say to the superintendent who's saying the kid can't finish out the year, well, what about 79-215 sub 4? And they'll go, and then they call somebody and figure out, oh crap, we do have this policy. So there you go.
But that says may.
Yeah,
so
most
the school can say no. And if this is a special needs, high cost student, won't they say no?
But the problem is, yes, the question is if that says may, that's permissive, and if this is a high dollar special needs kids, isn't the school just going to say no? But most schools, because NDE pushed this, have a policy that says what they're going to do with kids that move. Now, once you've got it by policy, you can't make a case-by-case decision when your policy says that you shall. The statute empowers the board to pick. But the other thing to remember is schools, even big schools like Lincoln are chasing those student aid dollars, right? Every kid in the door is worth about $8,000 to a school. Roughly, depending on how your state aid calculation works out. And so boards have written macro level policies to encourage attendance, even though on the micro level they may wish they didn't let this kid in. Yeah. Okay. Every so often, I still get a call from a parent or a caseworker that says, "We're just going to contract. Kid is from Gothenburg. Foster family lives in Cozad, but the kid's been in trouble both in Gothenburg and Cozad. We want to just contract with Eustis Farnham to let him go to Eustis." Okay. And parents used to be able to just sign a contract with the school and send their kid to a different school. That no longer exists. You can only contract district to district or out of state. Now the first part, district to district, does matter for you all, for the population of students that you serve. Every so often, well, not every so often, about twice a year, I get a kid who's just not succeeding in the student population that he's in for whatever reason. He's a cyber bully, he's a bully, whatever. And mom and dad aren't interested in optioning the kid, but the kid's not yet court involved, so I don't have any assistance from the court system. Eustis can just call up Gothenburg and say, "Hey, we've got a problem kid, and we don't think he's going to do well here because he's burned all of his bridges here. Will you contract to take him in Gothenburg?" And the two schools can sign a contract and then transfer obligation for that kid to the second school. Do you see who's missing from this contract? Parents. That's right. That's right. The kid is still legally a resident of Eustis, still reported on the Eustis, all the reporting stuff. So mom doesn't really have, it's as if the Eustis school district had said, "You're going to attend," it's just like in Lincoln when the school says which building you're going to go to. Okay, the school has that power. So we can contract kids around, and we have done it. We don't do it very much because what's Gothenburg going to say? Why do I want your bad kids, right? So it doesn't happen, but we do it, and sometimes it's successful, especially in the facts I've described. Small school, kid has just burned way too many bridges, or we got the emo kid that's wearing eyeliner and a big long trench coat, and all the kids in Eustis are freaked out by him. But in Kearney, it's just another kid, right? I mean, so we have had that be successful for kids. Yeah.
Okay, so parents are completely left out of that. You've got two schools that are negotiating. How does a kid get back and forth to the contracted school?
Oh, yeah, no. The question is, parents completely left out of it. You got two schools negotiating. How does the kid get back and forth? That's on the school, okay? Johnny shows up at Eustis, and it's on the school to figure out how, because the school has made that placement decision, so that transportation obligation is on the school. And we don't very often do this just over parental objection, because it's not going to be successful most of the time. We have the legal authority to do it, but if mom's mad about it and telling the kid every night how rotten the school is, we're not going to have great success. I don't care if you're processing, if you have a question. Okay. So, option students. For a long time, option enrollment was the answer to all of your foster care problems, right? Just have the foster parents option the kid wherever they want. Life is good. Foster parents do not, by statute and Department of Ed rule, have the authority to option enroll their students. Say again. Because I still have clients say, "Oh, we just have the foster parents fill out option papers." Psh, no problem. Foster parents don't have the authority to option the children that have been charged with their care. Now, we're going to talk about the Fostering Connections Act in a minute. Just put a little asterisk by this, and when I talk about the Fostering Connections, you'll see why we shouldn't and can't give foster parents that power, because it would completely carve out the whole purpose of the Fostering Connections Act. But here's a fact that you don't know, and my clients will be mad at me for telling you this. Parents who option enroll their students, who qualify for free and reduced lunch, keyword there being qualify, not receive, qualify for free and reduced lunch, are entitled to mileage for transporting their child from the resident district to the option district upon request. And my clients hate that. But the purpose of that, when the unicameral put that in, was to make it, because there's an interesting study, I just tweeted it. They did a 1,500 kids, they call it open enrollment in Colorado, but it's very similar to option enrollment in Nebraska. And they looked at who's open enrolling, What are the outcomes for those kids? Basically, you know, this is a school choice program. What's working? And what they found in Colorado is mostly students of high to moderate socioeconomic status, students who were highly engaged with highly engaged parents, those were the kids who option enrolled and were successful. The kids of moderate to low economic status with moderate to low engagement by kids and parents, when they did open enroll, they only stayed in Colorado on an average of 6 months and then they went back home. And transportation was a huge part of that. So in Nebraska, when they passed the option enrollment statutes, they added this mileage provision as in an attempt to address those economic concerns, but it's just not well publicized and well known by schools. So, and we're not out there offering, you know, hey, do you want some free money? But it's out there. And yeah, I'm a big fan of option enrollment. My clients, when it first passed, thought it was terrible. I think school choice is a good thing. If mom hates the school, kid hates the school, and the school hates the kid and the mom, really a fresh start. Hey, you know, I mean, I know we're not supposed to, but come on. A fresh start may be just what that kid needs. And I tell my clients, go, let them go someplace where they're happy instead of staying here and being mad at you all the time. So I love option enrollment, but it's got to be legal guardians in terms of adoptive parent, court-awarded guardianship, or biological parents. It can't just be foster parents or caseworkers. Okay, question. Now the hands go up. Just say.
This says parents eligible for mileage. Does that allow the foster parent?
Okay, so bio mom has signed the option papers. Foster kid is living in Louisville and wants to go to Elmwood. Yeah, that would be mileage from the foster home to the school. But bio mom is the one that has to sign the option papers.
Okay.
Okay, and I don't know how you figure out that kid's free and reduced lunch status. I mean, there's an answer. I just don't happen to know it, but I bet you guys do.
I've had several cases where family guardian item and both parents' rights have been terminated. HHS still has legal guardianship, and then there's a foster parent. So who has the rights at that point?
So that's both bio parents' legal rights have been terminated. HHS has a legal guardianship. There's a GAL. Who has the rights there? I am not sure that child has the legal right to option at that point in time. I think that's the law school exam A+ answer. But the practical answer is, in those circumstances that you've described, if DHHS, not the caseworker, but someone higher in DHHS signs those option papers, I'm going to advise my client to respect that option. But what would be better if you guys would just make a best interest determination and say it's in the kid's best interest to attend XYZ school? That's going to get that kid home better than an option enrollment.
You mean the court make that decision? The juvenile court?
The juvenile court can make a best interest determination under 43, what is it, 1413? Yeah. So the juvenile court could make a best interest determination, and once we get a court order, we'll do whatever the court says about best interest. Option enrollment is really, I live in North Platte, but I'm not good enough to play football there, so I want to go to Maxwell. You know what I'm saying? I mean, that's typically, I mean, I'm just telling you. And I think those are legitimate decision-making metrics, but I'm not sure we should be using option enrollment as a substitute for best interest determination. So there were a ton of questions. Yeah?
Is there a limit to how many times they can option?
Great question. There's a, yes. The default rule is 1 per kid, but then they keep tweaking it, right? 1 per kid, unless the school district you opted into merges with another school district, then you get another one. You get one when you complete all the grades offered by a school district. So if you're going, there used to be class 1s, elementary only, and you got another option then. They just tweaked it now so that if I complete all of the grades up through, if the school goes, is K-6 elementary and a 7-12 high school, and I've opted into that elementary and I say I want to go to someplace else for high school, when I complete all the grades offered in that building, I get another option. So the default rule is 1 per kid with ways to get around that if necessary. And their option enrollment statutes aren't in 79-215, they're lower down, 79-600 something. So if you got specific option questions, you should go look. But all schools are required to have a policy on option enrollment, so that's a handy way to cheat and go there instead of digging through the statutes. But you should think 1 per kid, and then they're with an asterisk. Other questions? Yeah?
These don't apply to the Omaha area, right? We have our own little
Well, actually, that's interesting. Then the question is, these don't apply to the Omaha area because of the learning community. And I don't do OPS, but I do several learning community schools. Actually, option enrollment does apply to the Omaha. If I go to South Sarpy 46, and I want to instead attend Ralston. No, South Sarpy isn't in the learning community, is it?
Yes, it is.
Oh, stink. Where I got to go further east. So I go to, help me, Council, doesn't count. Plattsmouth, there you go. I go to Plattsmouth, and I want to go to school in Ralston. I can option enroll out of Plattsmouth into Ralston. And a kid from Ralston could option enroll out to Plattsmouth. But now your question really is, what about the learning community? That's called open enrollment in Nebraska. And if you're within a learning community, you don't have to go through the option enrollment process to change schools. You go through the open enrollment process. Yes. But I get nervous when my Metro clients say, oh, we don't do option. That's not really true. Oh, if an option, okay, so here's something else I think that you guys might want to know that you don't know. So I live in Plattsmouth. I live in Ralston. I transfer into Plattsmouth through option enrollment, okay? I'm a severely behavior disordered child, and somehow I sneaked through and got in under an option enrollment, right? Now, Plattsmouth decides we can't handle this kiddo. We're going to ship her to ESU 3's behavior program in Plattsmouth, or in Papillion, all right? Who pays for that? The school district where I optioned into pays for my programming, but Ralston, the school district where I came from, pays for my transportation. I know, it's weird. It shouldn't be this complicated, but it is. Just the option enrollment statutes say once a student is an option student, they're a resident. So I get everything I would ever ask for, even if same as if I lived there. The only difference is if I'm placed out of the district by the optioning district, the school district of residence has to pay transportation.
Why?
Ask the education committee. I don't know. I mean, I'm asking why, that leads to madness. Don't do that. Oh, 79-241. The two must be the 240s where the option enrollment statutes are, not the 260s. Okay, I love this cartoon. Okay, so now let's get into your kids, state wards who are and foster kids. So there's a specific provision for children who are state wards who have not been placed in foster care. That's you probation. That student remains a resident of the school district in which he or she resided when they were made a state ward. There's an interesting case in Nebraska. A kid lived in the Fairbury school district, was made a state ward, right? And here's the way it looks to schools. The kid was made a state ward and he disappeared. And school had no idea where he landed, what happened. They just, go with God, we hope the best for you. So he floats around the state to various and sundry residential facilities and this and that and the other thing. Finally, kid shows up in York. And York says to Fairbury, hey, we've got one of your kids, go ahead and start sending money now, right? And Fairbury said, he ain't our kid. He hadn't lived here in 6 years. I mean, the aunt, I think, is who he lived with when he was made a foster child. The person who was in actual or physical control of him when he was made a ward, not foster, warded, that person didn't even live in the district anymore. There was literally zero connection between this kid and the Fairbury School District. York and Fairbury went to the Department of Education has a dispute resolution process, like an administrative trial proceeding. Fairbury lost that case. Okay, when the child is made a foster child, when he or she lives in the school district, I tell schools, this is a terrible analogy, so please don't be mad at me, but I tell schools it's like stepping on gum on hot pavement, right? He's stuck to you. No matter how many places he goes, you're responsible for that student until either he becomes a resident someplace else or he's dewarded. And schools learned that lesson because that Fairbury case got a lot of high-profile coverage. So if you say to schools, he was made a state ward in your district, they'll probably give up the fight and go, yeah, I got to pay. Okay? Questions on that? Did you know that? Okay. I just want to make sure I'm not wasting your time. Now, if the kid is placed into a different school district, placed into an institution with a SPED program, then the state pays. This was a bigger deal when we had the I Believe in Me ranch, and there were some private providers for a while that the money really mattered. This is a huge deal to schools, okay? If a child is special needs, there are all kinds of obligations that go under IDEA, the record keeping, potential litigation by the parents, funding, subpart B versus subpart A. There's all this stuff that you don't care about, but know that this statement has big consequences for schools, okay? The resident district then is still responsible for the child's IEP. That means the kid's case manager for special ed purposes will be a teacher or an education professional that may not ever see the kid. They just sit in on the IEP meeting once a year. But that's where that legal obligation remains. That's why that's one of the reasons residency is such a big deal to schools, because it's who's on the hook for the IDEA, who's on the hook for paying for stuff, who's on the hook for statewide testing. Yeah, Trish?
If I have a kid that starts in Lincoln, becomes a ward in Lincoln,
Yep.
moves to...
And he's not in foster care. Let's say he's not.
Let's say
Because it matters. No, then I make that point because 79215 sub 9 is students who are state wards but not in foster care. Sub 10 is foster kids, which is a different, so it's a difference that matters a lot. So anyway, made a state ward, not a foster.
Okay, starts out in Lincoln, moves or placed in foster care in Seward.
He can't be placed in foster care, but he's living with grandma in Seward informally, not because he's in foster care. It happens. It happens.
So, but this kid goes to Seward. And the child has an IEP.
Okay.
Do we do the educational best or the best interest letter at that point to say, okay, he's going to Seward. Let's say then this kid has a real big disruption and is placed in a residential treatment center in Omaha.
Okay.
Now, my understanding is that I will tell workers then we have to go back to Lincoln and say, Lincoln, this is your kid as far as the IEP.
Okay, so
Shouldn't we have kept Lincoln in the loop when that kid went to Seward?
yeah, so I'm gonna tweak your scenario just a bit to make sure it fits under here. But I see what you're asking, Trish. Okay, so I am in Lincoln. I become court involved for whatever reason. Let's say I have a law violation because that makes life easy. Then I go to YRTC, and we'll pretend like they aren't state run for the moment, right? So I'm going someplace that's not just to live with I'm trying to make myself not a foster child. So, but I have a big blow up at wherever I've been sent to, and I go to Omaha, right? Now who pays? If no other school district has taken that kid as a school district of residence, then Lincoln's on the hook, right? But if Lincoln's on the hook, then Lincoln is the one that has run that kid's IEP all this time, right? Here's what I'm trying to stop from happening. A kid goes to Madison, and the folks at Madison just run their own IEP meeting, create their own IEP, don't talk to the local school district. Well, guys, you can't have responsibility without any power. That just does not work statutorily, and it doesn't work sort of as a matter of public policy either. So when this kid is transient like that, we got to figure out who the school district of residence is. Now, if he's gone from Lincoln to Seward and there was a best interest determination, then he's Seward's, right? Lincoln is dead to him. And if he goes from Seward to Omaha, it's Seward. Because Seward is now his district of residence because you made him a resident of Seward when you made that best interest determination. You can't just it's not, oh, never mind, we were just funning about that, and you switch that obligation back to Lincoln, right? Once it's switched, it's switched.
But what happens, let's put the foster placement in that
Okay.
scenario. If they were made a ward in Lincoln, they were placed in a foster home in Seward.
Yep,
And we wanted that child to attend Seward.
yep,
And the child has an IEP.
Yep.
So Seward takes over, but then that child then is disrupted and placed in a PDRTF
yep,
in Omaha.
yep.
Lincoln.
Nope. Lincoln resident made a foster child fostered into Seward. You make a written best interest determination under 43, 14, 13, whatever that is. And then he's disruptive in Seward. When he goes to Omaha, Seward is his school district of residence.
Department of Ed told me that it would still be Lincoln.
Then we don't have our facts right. You and I are not understanding. The factual scenario that we've just discussed, I know with 100% certainty that Brian Halstead, who's general counsel at NDE, Once that best interest determination is made, residency transfers to the district where best interest is made. Now, maybe if you talk to somebody in SPED, you talk to somebody, I mean, this sounds horrible, but you know, NDE is not monolithic, so they don't always talk to each other. But the best interest determination transfers residency. And so Seward has that kid. And if you email me who you talked to, if it was Rose Demachek or whoever, I'll call over and square that away.
Okay. But we actually had, my case is similar to the one you mentioned, but it's not the same. But the kid was made a ward when they were 3 in Greeley, Scotia. Nobody, no parental rights intact, nobody ever, I don't even think anyone from that family lives there, and he hasn't lived there since he was 3. He's gone to Omaha Public, he's gone to Bellevue, he's gone to Elkhorn, then he was placed at ESU 3. That entire time, Greeley, Scotia funded it.
Yep.
They were a part of everything.
Yep.
We then determined best interest. Now OPS is his resident district,
right.
And so Greeley, Scotia is done. But if I had
because Greeley's one of mine, so we did it right for once.
But if I had never done that, if I
That's
had
right.
not done the best interest, and I decided then that he was going to go to Ralston, or he was going to be placed at somewhere in Lincoln, and he was going to go to Lincoln Public, Greeley, Scotia would have stayed.
Yep. Yep. So the scenario you're talking about, it's Greeley Walbeck, Northwest Scotia. Thank God they just changed their name to Central Valley, so we don't have to.
No.
I know. But kids from Greeley, since he's 3, he's been troubled. You know, God knows where the family is. He's been in Omaha. He's been in Ralston. He's been at ESU 3. I don't know where else you said. All that time, Greeley Walbeck was his district of residence because he was made a ward when he was in Greeley, and there was no best interest determination made to transfer that obligation to somebody else, right? So Greeley's been on the hook for that kiddo and bitching about it, complaining to me about it for 12 years, let me just tell you, complaining bitterly about it. And so schools know district is responsible for the kid once the kid has made a state ward. Now the issue that Trish is...
I didn't know we could do the best interest letter until 2 months ago, and that's when we did it.
And that's okay. I mean, it's okay. I'm not, and I understand schools all of us are learning this stuff. Our understanding is imperfect. And that's why I think Trish's question about kid lives in Lincoln, warded in Lincoln, placed in foster care in Seward. If there's a best interest determination, that would transfer residency to Seward. Somebody could be thinking, do you see how little differences matter, right? Whoever you talk to in the department might be thinking we've got this scenario here of the kid from Greeley Walbeck where there never was a written best interest determination, the kid was just attending. And it used to be, before we got serious about the Fostering Connections Act, kids just went wherever, right? Nobody asked any questions. And because of changes in the federal law, we've changed our law. Yeah?
What is the best interest letter?
Okay.
Is that an order, or is that something the department?
That's a great question. And okay, so that's 79-215 sub 9. This is students who are foster, and this is going to answer your question. So if I am a foster child, I remain a resident of the home district. And under the Fostering Connections Act, I'm supposed to continue attending the same school building that I attended immediately before becoming a foster child, okay? Unless there's a best interest determination, I'm telling my schools it used to be everybody defaulted to 79-215 sub 1, so if the kid showed up, we enrolled them, right? Now, I think I have, yeah. Okay, Fostering Connections Act is federal statute. You can see how it flows into the federal regulatory system. But it required states to change their child welfare laws to make it so that foster kids weren't changing schools as soon as they were fostered, okay? Now, I'm going to give you the song and dance that I give my schools, and you probably know this, okay? But this is good. I believe this to be good public policy. I am a 6-year-old, right? The only life I've ever known is living with mom who has a series of abusive boyfriends and has a real problem with alcohol, right? My life is pretty chaotic. I'm not really sure who's going to be home when I get home or who's going to be there when I wake up in the morning. I don't know where my next meal is coming from, but I know when I go to kindergarten that Miss Kathy is always in the classroom, and I know that the lunch ladies always have lunch at the same time every single day, right? HHS finally gets involved in my life, and I get removed from the home that mom's been providing me. And I get sent to a very nice family, but they smell weird. They make me sit down to eat. You know, I'm no longer allowed to play video games until midnight. My whole world is turned upside down. Now, it might be for the better, but it's a staggering amount of change. if I continue, if I stay in the same school building, guess who's still there every day? Miss Kathy, that's right. And the same lunch ladies, and it's the same, I have the same red, yellow, green discipline system. You know what I'm saying? I have that, the one element of calm in my life, consistency in my life remains. Now take the same kid, take me out of the same bad situation, move me from Lincoln, where I've got Miss Kathy, and move me to Seward, where I've got some weirdo named Mrs. Jones, right? And instead of red, yellow, green, there's this weird thing where I get a playing card and I turn it upside down, right? And the lunch is different and I go at a different time. You see how that, now my whole life is turned upside down. So I just really earnest, and let's face it, the kids that you guys are working with, that I come into contact with, they don't have great chances for high educational success. I mean, the statistics on how these kids place and test are abysmal. And shame on us. Shame on us, because we're raising a generation that's going to raise another generation with the same problem. I mean, their chances are grim. So the least we can do is to try to leave me in Miss Kathy's classroom, okay? I had a family, I can't remember if there were 4 or 6 kids, a ton of them, and they were wild. And they finally got placed, Mom finally got housing in like Exeter, and we were busing him every day back to Lincoln. And the caseworker just thought that was the most ridiculous thing ever, and I just insisted that we continue that, because we were Exeter, because those kids just, the least we can do is leave them in the classroom. Okay, so I'm sorry, I don't mean to preach to the, you guys know these problems better than I do. And hey, I've got the luxury of saying that when I'm not the one looking for a foster home in Greeley to leave them in Greeley. You know, I get that. But that's the public policy behind the Fostering Connections Act. So let me just finish up to answer this question, and then I'll come back to you. So the Fostering Connection Act assumes that the kid is in the same school. The child's case plan must include an assurance that the state is coordinated with appropriate local education agencies to ensure that the child remains enrolled in the school in which the child was enrolled at the time of placement. That's the federal law. So we've done it, whoops, I didn't put the language in, sorry. We've done it in 79-215 sub 9. It says the child should continue attending the original school building unless there's a best interest determination. That's the only thing in our statutes, best interest determination. The Department of Education has told us that it must be in writing. That's all I know. Now, it refers back to 43-14-13 or 13-14. I'm sorry, I can't pull the language. And that says either the court or the case plan. But I'll tell you, my schools, I'll take anything. Anything written down on a flat piece of paper and signed by somebody that I can say it was her, or sorry, it was him. I have seen courts issuing best interest determinations, which I love, because then it just makes me feel like somebody's looked at this and said this is where this kid should go. Okay, so but once that best interest determination is made, then in under 79-215 land, that child's residency then has transferred to that school, and that's where they're a resident. And the connection to the original school district of residence is sort of severed unless they land back there someday. Does that answer your question? All right, now I see lots. So yeah, and then I'll come.
You said you have seen courts do it.
Yep.
If it's not courts, then it would be somebody from the school district. Is that right?
No, it has to be somebody from juvenile justice. So DHHS, probation, or the court. And I think, and Judge Gindler, I missed the last one of the meetings. I think DHHS is like revising their forms to make that a form, a change in placement form. And there's going to be an actual systemic way for DHHS to do this.
There'll be an educational best interest checklist on the form to inform the parties as to what their recommendation is.
That's awesome. Oh, sorry for the tape. There's going to be an actual educational best interest determination form with a checklist. And I just want you to know that as I talk to educators, switching schools becomes a bigger and bigger deal even as the kids get older. And North Platte's a great example. They're on block scheduling. And so where you might take 8 classes if you go to school in Maxwell, 8 classes if you go to school in Maxwell, when you go to North Platte, you may only have 4. And if you've been in North Platte, you've only had 4 classes. Do you see how that means transferring between high schools in Nebraska is really tricky. Curriculum is all locally determined. Now, we all take the NISA test, so we have a way to look at schools, because the unit camera wants to compare schools. But that doesn't mean we have a uniform curriculum or a uniform system of dealing with kids. And so that checklist, I think, is crucial. That if, for those of you that are case managers, GALs, and COSAs in the room, please, I'm begging you, pick up the phone and call the two schools involved. I can't believe how rarely that happens. And just say, you know, I've got a sophomore, academically he's a freshman, he's taken US government, but no biology, no science. And what would that kid's schedule look like in your school? Because it's just, kids get, I mean, I get calls all the time where kids are just dropped in like from outer space, and the kid's mad because obviously he's already had algebra, he's got to sit through it again, or he's in calc and he's never had, you know what I mean? It's just very frustrating. So there's that. Yeah.
So you said you would accept a best interest letter from a caseworker?
All my guidance is it says best interest determination pursuant to the juvenile justice statutes. Okay. So I'm not going to quarrel. If a caseworker gives it to me, I'm taking it right now.
Then that would trump a parent's educational?
Isn't that crappy? But that's how I read the statutes. Yeah. Now, if the parent's kicking up a stink about it, lots of times we'll go back to DHHS and the caseworker and say, are you sure? Or if there's a court hearing pending, sometimes I'll send my school to show up and, yeah.
I think it's interesting.
I think Nebraska's done a poor job of providing statutory guidance, but I'm limited by what is in 79215 sub 9, and it says it doesn't even say written, right? So for a while, a caseworker would show up and say, oh yeah, it's in his best interest. And then so we at least are requiring it to be written now so that we know who said that. Yeah.
Okay, so I have a kid who was pulled out of a house to go to a group home.
Yep.
In Omaha.
Yes.
And the whole issue was we're having a terrible time getting him transported down to his home school. But the way you're talking, the home school should be paying for that transportation.
Oh, no. Well, no. No, it would be, to tell you the truth, it would be easier if the unicameral told us that. So you've got a kid that's been pulled out of a family in Lincoln in a group home in Omaha, right? So he's not homeless. If he was homeless, Lincoln would have to pay, right? Yeah. But so now in that situation, DHHS is on the hook for transportation because they're the ones that have determined where the kid's going to be. I mean, there's a certain logic to it. So it's on DHHS to figure out how to get him back to Lincoln. And then what does DHHS do? Well, they say, well, we don't have any van drivers, so it's in his best interest to go to school in Omaha. Yeah. Which I don't think that's good public policy, but I understand why that happens. But understand that Lincoln doesn't want to be running a shuttle service any more than it absolutely has to. So Lincoln's not going to pay for that kid's transportation unless he's homeless. I know, that's where the whole system breaks down on that question of who pays for transportation. And if you want to lobby the unicameral for clarity, I think schools would benefit if we had better. But right now, everybody looks at each other and says, well, who's transporting? Yeah. Okay, yes?
And you may be getting to this. This is just kind of playing in my mind now with the new probation system, LB 561. Those kids aren't wards anymore.
Right.
So, how's this going to work?
Yeah, I know. With the new probation system, those kids aren't wards anymore, so how's that going to work? Ideally, that system's supposed to leave the kid in place, right? So hopefully we don't have 79215 problems because he's staying where he belongs. Yeah. But he's not. And anytime the court has, the problem is, did you know that state ward is never defined in statute anywhere? What's a state ward? I don't know. I spent 3 hours one afternoon going, this has got to be somewhere. Nope. So through talking with the Department of Education and other education attorneys, we've sort of shrugged our shoulders and said, you know what, if the kid is court involved, he's a state ward. Well, just to solve that very problem. So then we're treating him as a state ward, not in foster care, and so that those provisions kick in. Because I don't know what else, isn't it? So the whole subheading turns on whether or not the kid's a state ward, but we haven't defined what a state ward is. So I'm calling it court involved. If your name is in the caption of a lawsuit of something in front of a judge, we're calling you a state ward, which is not perfect, but something. Was there anybody else over here before I go back over to Tricia? Yeah.
Okay. Trying to go back to your other thread. Okay, so school doesn't want to run transportation because he's not homeless. However, if this was home school district,
right.
And she qualifies for free lunch, they do have to provide mileage.
I'm so sorry. I wish this was less complicated no, okay, so this is, mom lives in Lincoln.
Yeah.
She doesn't get mileage because that kid is a resident. The only way you get mileage is if you've optioned into a different school district. So yeah, we're back to the obligation to transport's on the family at the home school district, which
where's the money for transport?
there is no HHS.
Unless the kid was optioned into this Greeley.
That's right. If the kid was optioned into Crete from Lincoln, now the option district would have to pay the transportation. But yeah, I feel both good and bad that you asked that question, because it lets me see that you're all starting to see the complexity of this, but it also makes me think you're going to be frustrated when you're like, wait, is it option? Is it open? Is it,
No,
I know
all
it's...
all I hear out of my home public school district is, we can't, we're not going to do that, we can't. There isn't any money for that, we're not going to. Sorry, your fifth grader's only got 4 more weeks of school, we're not going to McKinney-Vento even though she's homeless in Elmore. Sorry.
Okay, they're not one of mine,
right.
But they're wrong about McKinney-Vento.
Oh, I know that. No,
but I do understand, again, let me go back to what I said at the beginning. None of us have been given them, we've all been given obligations, and none of us have been given sufficient money. And the other thing is that schools have kind of learned a bitter lesson, which is the better you serve these kids, these super expensive, super involved, super difficult kids, the more of them you get. You know? And they've learned the wrong lesson from that, which is the more obstreperous you are, the fewer problems you're going to have. So, and I'm not proud that they've learned that lesson, but I see why they did. So, and if I know who represents Elkhorn, we can talk. And because
it's just what I'm hearing today is there's a lot more wiggle room there than I thought was.
Yeah, there is.
Which is kind of cool.
Yeah, there is. Yeah, there is. Yeah. Okay.
As far as the education best interest determination or the best interest determination, I rewrote the superintendent letter, which will come out this summer, and I'm hopefully doing a training at some point. We have included that statement if the child is changing schools and that determination is necessary. That we have decided then that it is. I know.
So what you're telling me, Tricia, is the superintendent's letter just says, oh, and if you're getting this letter, we've made a best interest determination.
No.
Okay, good, because I hate that.
If that determination is necessary, then it will be included. But it will
Okay.
If
So you're going to say, please see, if there's a best interest determination enclosed, we've made it.
Correct. So
Okay.
Also, what we were instructed by the Department of Ed is, and what I've told case managers, is at the end of the day, a guardian is the one that has to make that final decision if there's a dispute. So what we're telling case managers is, at the end of the day, you have to make that decision. Now, we don't want to trump what parents want, and we want to make that a decision as a team. But if there is a dispute and we have to make it, we have to make it.
Yeah, at the end of the day, and I think that is absolutely true. At the end of the day, the guardian has to make that decision, if that's the manager or whoever, but you got to make it pursuant to 43-13-14 through a best interest determination. Now, what I was afraid you were going to say is we've changed our superintendent letter to say, dear superintendent, if this kid shows up, that means we made a best interest determination, wink, because that's kind of the old system. But if you're going to work through the worksheet that HHS is putting together and enclose that, that is awesome. And caseworkers, if you would include that information to the receiving school district, it would really help. For example, if you say, well, we've decided to put this kid in your school because you have golf. Okay, bad example. You have cross country. Everybody has cross country. You have wrestling. There's one that every school doesn't have. You have wrestling, and this kid is interested in wrestling, so that helped us decide. That's data the school should have, that the things that you considered in making that best interest determination. Where'd my clicker go? Okay. So now you're all going to go home and flag 79-215 in your statute book, right? Because you can see how we have to trail through it all. Click, click, click. Oh, huh. Is this, oh, I just want to touch on the Uninterrupted Scholars Act, and then we'll take a break. The Federal Uninterrupted Scholars Act makes it so that it should be easier for you to receive information from school districts when a child is involved in the foster care system or the court system. That's the Uninterrupted Scholars Act. I'm not going to go too deep into the weeds about FERPA and IDEA. Do know that this is new. There was guidance issued by the U.S. Department of Education just as recently as a week and a half ago, and so schools are learning about it. But if you've got schools consistently saying, I can't give that to you because of FERPA, I can't give that to you because of IDEA, if you mumble Uninterrupted Scholars Act, it may make them, that's a place that has changed the law. And I mean, we could spend an hour on that, but basically the result should be you should get data more freely. Now, what my schools say to me when I tweeted about this, when it was first passed, I got like 5 replies from schools, not just Nebraska schools, on Twitter saying, yeah, sure, if only we could get information from them as easily as we give information out. So do understand that the schools perceive they have a need to know more from you, but they do have a legal obligation now to give information to you when you ask for it. Okay? Now, I feel like, oh shoot, I keep thinking that we're going to take a bathroom break. As soon as we get through 79-215, we're going to take a break. Non-wards who are residentially placed is becoming less of an issue because money doesn't matter as much. So I've got one right now. 3 kids from Omaha are in a group home in Weeping Water. Okay? Weeping Water has contracted with BEST, which is an educational facility here in Lincoln, to provide educational services for these boys because they're in a group home for a reason, right? And Weeping Water just didn't have the behavioral support services that those kids needed. Weeping Water then wrote to Omaha Public Schools, said, Dear Omaha, we've sent them to BEST, please send money. And pursuant to sub A of 79-215 sub 10, Omaha was required to contract with us for those kids, all right? This gets into the weeds maybe that you don't care about, but there is a way for schools to have money transfer back and forth, which matters a lot to schools. But if the wrong district pays, the correct district has to reimburse at 110%. There's a little incentive there to get it right. And then there is a process for schools to fight it out with NDE, which I think is what you guys need to know. Look, if you guys can't figure it out, you go to the Department of Education, but stop jacking me around, I think, is your line. If they do have an education program the Department of Ed pays, I spent like 3 years writing letters to Boys Town saying, Dear Boys Town, my client's not going to pay you. Because there were all these predicates that we had to get for Boys Town to get paid. That problem was solved by now Boys Town bills the Department of Education directly. I'm slightly concerned, not that I think Boys Town is a bad and Boys Town is an easy, they're the king poobah of residential facilities in Nebraska. But nobody at NDE is asking whether the Boys Town placement is appropriate, right? Or whether the Boys Town services are being implemented with fidelity. And I think that lack of accountability is a weakness in the system that we have. But it solved a lot of problems and saved school districts a lot of legal fees because I'm not having to fire off letters to Boys Town all the time. But here's the key I want you guys to remember that I'm preaching to my clients and that they're kind of forgetting. Because once there's no check being cut, there's a temptation by the school just to say hands are off, right? Legally, the school's obligation continues as far as what the IEP says if it's being implemented, and for NSSRS, which is Nebraska's data collection, testing system, all that remains with the resident district. So there still should be involvement by that district with the kid that's placed in Boys Town, and I think what happens now is we kind of out of sight, out of mind them. Okay, now we've got detention. The statute is silent about where a kid who's in detention resides, which is a great oversight, right? Who goes and does testing? Who assesses that kid that's here in the youth facility in Lincoln? Is the statute silent? I'm telling my clients that we should assume it's the resident district. I think that kid is a state ward. Again, since we don't know what a state ward is. So I'm telling the resident district that they still have NSSRS. I have somebody from York that drives to Lincoln to assess, do the NISA tests. And then but that IEP also would be with their local district. Okay? And schools don't like that either. They think the state takes over. And I keep saying there is no state teacher. I mean, there's no, the state doesn't have an IEP system. It's all school driven. But you might get some pushback on that. But the school attorneys and the Department of Ed are pretty uniform on that. All right, now we can take a break. We've had a lot of coffee and you need to rest your brains. Let's come back about 10:05.